everyone, my name is Esmery McCallaghan, and today I have the privilege of having a little chat with Volker Krüger from our firm, who heads our estates department, to talk a bit about National Wills Week that's coming up, as well as wills in general. So Volker, before we get to a general discussion on wills, just tell us a bit about what is National Wills Week.
It's a week that is sponsored every year by the LPC, the Legal Practice Council, during which people can get their wills drafted free of charge by participating attorneys' firms. So you can check on the website of the LPC which firms are indeed participating, and then contact them and make an appointment for that week, and then they will assist you with drafting a simple will and your estate planning, etc.
I think it's a very good initiative because then anybody, regardless of who you are, can get a will drafted for free by an attorney.
Yes, and it's certainly important to have a will. If you don't have a will, then the interstate law of succession applies and stipulates who must inherit what in terms of the assets in your estate after you've passed away. And that will in most cases not be in line with what you would prefer should happen. So it's very important, I think, for everybody, young and old, to have a will, and in that will prescribe what should happen after you've passed away.
Certainly. Now, Volker, I've seen that a lot of people have a few interesting questions about wills. Now, one of the questions that people tend to have is, do I have to register my will somewhere for it to be valid?
No. So there's no central registry for wills, like, for example, there is for title deeds in respect of a movable property, which are registered at the deeds office. So in the case of wills, you simply have to comply with the formality requirements of the Wills Act, in the sense that the document must be signed by you in the presence of two witnesses, who must also then sign the will in your presence, etc. That's the basic requirement that has to be met. There are some exceptions and some alternatives to also use to have a valid will, but that's basically what you have to do to ensure that there's an enforceable document that can then be used after you've passed away. And only after your death will it then be lodged at the master's office. So then it goes to the government, and then there's a registry of all the wills that are lodged there after you've passed away. But before that, there is no central place where the wills are stored. So most people, if, for example, you use your attorney, then you would sign your will at the attorney's office, and they would then keep it in safe custody in a fireproof safe. Most attorneys don't charge for that, in my experience. So then you know it's safe there, and you obviously get a copy. And it's obviously also important to tell your loved ones where your will is, so that they know where to go after you've passed away.
Interesting. Now, on that point of having two witnesses sign your will, can I, for example, write my will out on a piece of paper, bequeath everything to my wife and son, for example, and have them sign as witnesses, and I put it in my drawer at home? Would that be valid?
Witnesses are disqualified from inheriting in terms of the will, so you shouldn't use your spouse or whoever you also make a beneficiary in the will as a witness. So that's very important to keep in mind. There's an exception. They can still inherit to the same extent that they would have inherited in terms of the interstate law of succession, but you don't want to have to work with those exceptions or whatever. So rather make sure that you use independent witnesses. Anybody 14 years or older can actually sign as a witness, and the person obviously doesn't have to understand the contents of the will as such. You basically, as a witness, just confirm the fact that the person, the testator or the testatrix, signed in your presence. So that's all you're doing. So yeah, don't rather use any family member that would also be a beneficiary as a witness. But in any event, I wouldn't suggest that you draft your own will. Make sure that you get an expert to do it properly, so that it can be executed, because people often think it's simple. I just stipulate who must get what. Why do I have to use an attorney or someone else, a professional person, to help me with the drafting work? But unfortunately, there are a lot of court cases that stem from such self-made wills because there are contradictions, so it's not clear what the intention is, or the formality requirements have not been met. So rather make use of this Wills Week and get it drafted free of charge. Even if you do it outside the Wills Week, it's not going to cost you a lot of money to have a will drafted, and it can certainly prevent a lot of headaches.
For sure. Now, regarding executing your wishes after your death, Who can be an executor? Can you appoint anybody as an executor? Can an executor also inherit from you?
Yes, so you can, for example, appoint your surviving spouse as the executor or executrix, and she can then also be a beneficiary of the will. So pros and cons. Some people like to appoint family members for them to then seek professional help, like an attorney or whoever, to assist with the winding up process, because the surviving spouse would normally not know how to attend to all the requirements of the master and the SARS and the government, etc., to make sure that the estate is wound up properly. So that is one option. Some people prefer appointing an independent person, like a professional person, who has the necessary experience to do the job properly, and who can also make sure that there are no disputes between the family members and the beneficiaries, etc. So in my experience, an independent executor can often add a lot of value by making sure that the emotions are put aside and the law is followed and everybody objectively accepts what needs to happen in terms of the will, etc. So in my experience, that first meeting with the beneficiaries after someone has passed away is absolutely crucial. And if that is an experienced person that deals with that first meeting and not a family member, an outsider who's professional and who has the necessary experience, expertise, then you can prevent a lot of disputes, a lot of misunderstandings also. Sometimes it's not ill intentions or whatever, mala fide family members necessary who cause the problems. It's often misunderstandings and also the perception that an executor who's also a beneficiary will then wind up the estate to his benefit or her benefit, etc., and abuse that position of power that an executor actually has. So in that sense, it's often, I think, sensible to rather use an independent executor, especially if there's more than one beneficiary. If the surviving spouse inherits everything in any event, then I guess it's a simpler process and less risk that there might be disputes. But if there are various beneficiaries, especially surviving spouse and children, then it's normally, I think, better to look at an independent executor.
I agree with you. From a litigation perspective, I know there's many court cases about family members fighting about who gets what, and it often happens that children and parents are now fighting with each other, which is never a desirable situation for anybody.
I can maybe just mention, I've had numerous clients in my office who said to me, my children will never fight. Don't worry, they get along well, we're a close family, etc. And then when dad is no longer there, or mom is no longer there, or both are no longer there, situation
different story.
It's a completely different setup. And unfortunately, in many cases, the in-laws also get involved. I see that a lot. And that creates a lot of tension, and then there are disputes. So yeah, unfortunately, that happens in many cases.
Better to have an independent person, yes. Now, another question that a lot of people wonder about when it comes to dividing their assets after their death is, and the question that people tend to ask is, will the government take everything? And I assume that refers to perhaps a state duty. So maybe it's wise that we just give a brief overview of what is a state duty. Will it be payable? Are there exceptions? How does it work?
Well, the good news is that everything that the surviving spouse inherits is exempted from estate duty and also capital gains tax. So that problem you will not have after the death of the first dying spouse. There's a general exemption that covers the surviving spouse. So that's good news. After the surviving spouse, however, has passed away, then as a general rule, everything in the estate of the surviving spouse is indeed taxable in terms of estate duty and capital gains tax. However, in terms of estate duty, there is a primary rebate of 7 million rand that can be deducted from the estate at this stage. That's the amount. Might change in the future. The estate of the surviving spouse in terms of estate duty, if the surviving spouse inherited everything from the first dying estate. So the 3.5 million rand, which is the general primary rebate, and every estate is transferred from the first dying estate to the survivor's estate, and then you've got a 7 million rand deduction that you have available there. And then from there, over 7 million rand is taxed at 20% at this stage, and over up to 30 million rand, over 30 million, it's then 25%. So that's in terms of estate duty. So yeah, unfortunately, that must then be paid to the government in terms of estate duty. There's also capital gains tax payable in some cases. There's also a VAT payable in some cases. If, for example, the deceased was a farmer who was registered for VAT, then you would also have to declare VAT on all the assets that are part of the VAT enterprise of the deceased, etc. So, yeah, unfortunately, the government does take its share. Many people will argue not its fair share, but they take their share of the estate in terms of taxes. But fortunately, that is it. So it's not correct to say that the government takes your assets if you pass away without a will or whatever the case might be. Some people seem to have that perception. Even if you don't have a will, then the interstate law of succession will apply, as I mentioned earlier, which stipulates who must then inherit what. For example, if you pass away without a will and you have a surviving spouse and children, then they would be entitled to inherit in equal shares in terms of that Interstate Law of Succession Act, provide that the surviving spouse is entitled at this stage to a minimum of 250,000 Rand, for example. Or if you pass away with a surviving spouse only, then she would be the sole beneficiary if the wife is the surviving spouse. If there's children only, then it would go to the children. If there are no children, no surviving spouse, it goes to the parents, and thereafter to brothers and sisters, siblings, etc. So there is an act that prescribes who must get what if you pass away without a will, so it doesn't just go to the government.
Okay.
However, another case where it does go to the government or is under the control of the government, very important maybe to mention, is if there are minor children and there are, for example, cash inheritances that those minor children are entitled to. Then the law says if you don't have a will that, for example, caters for trust, then that money is paid to the guardians fund of the government to protect minor children up to the age of 18. You become a major at the age of 18 in South Africa. So that guardian fund is then in control of the funds, and whoever looks after the children must then apply to the guardians fund for the release of those funds to make them available to look after the children, which is certainly not the ideal scenario.
Yes.
So what we always advise our clients is if you have minor children or grandchildren that you want to benefit from your estate, you should cater for trust and appoint trustees who can then make the money available to the children as and when they need it. And then you can also link another age to that trust, because you are a major, as I mentioned earlier, with 18 years of age. But many people feel with 18, you maybe not yet responsible enough. You're going to blow the money on cars and girlfriends and overseas trips or whatever instead of studying.
Yes.
So many people, my experience, feel that 25 years, some even say 30 years, is maybe a better age. Then the children start getting a bit more responsible. So you can then also stipulate in your will what the age should be. So the idea is not to punish the children against punish them, just basically to protect them against themselves, to make sure that they rather act responsibly. So the trustees can still make the money available to the children as and when they need it for whatever, maintenance, studies, etc. But they then have the final say to make sure that the money is not wasted.
And this is why it's so important to have an attorney assist you with drafting your will, because if you write your will out on a little piece of paper or you don't have a will, then you wouldn't know about this situation where if your minor children were to inherit cash, it would go to the guardians fund at the very least up until the age of 18. So this is why it's so important to have a professional assist you with drafting your will.
I agree.
Yes. So that is it from my side. I think it's a very interesting information to take with you and remember and consider when you want to draft a will. And I would really encourage everybody to make use of the opportunity of National Wills Week every year to have your will drafted. Or even if you have an existing will, remember to review that will every few years because your circumstances might change.
Yeah, maybe I can just add, so the Wills Week also includes that, review of your will. It doesn't necessarily have to be a new will. So if you have a will already, you can also take that to your attorney who's participating and have that will reviewed. This year, maybe I can just also mention that it's the 12th till the 16th of September. So those are the important dates to keep in mind. So 12 to 16 September 2022, you can participate in the Wills Week and have your will drafted free of charge.
Or reviewed.
Or reviewed.
Yes. Thank you, Volker.
All right.
Please remember to like this video and subscribe to our channel.